Mr. Lopez here on Miss Nelson? Yes? Wow, okay. Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for December 7th, 2021. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Pantoja, would you call our next case?
Yes, Judge. Annex, if we could get Benjamin Duarte, please. Benjamin Duarte.
I received, I think on Rios, Mr. Avila, is it just one dismissal?
It's just one, Judge. The other case is still open.
Okay, just checking. Is that Mr. Duarte? Ms. Lerma, are you there?
Ms. Veronica Lerma. Very.
The next case, Chewy.
Yes, Judge. Annex, if we could hold off on Mr. Duarte and if we could get Daniel Nevares, please.
Yes, sir.
Thank you. Mr. Anderson, Greg Anderson.
I'm here. Judge, I'm having some difficulty with my video, but I am here. I hope you can hear me.
I can hear you just fine, Mr. Anderson. We've had so many internet technical issues lately. No worries. Let me just double check. Can you see your client?
I can see him. That
Okay.
is him.
Let's go ahead and get started, Tree.
Yes, Judge. It's cause number 2021-0D0-2017. Cause number 2021-0D0-2206. Cause number 2021-0D0-2003. And cause number 2021-0D0-0831. State of Texas versus Daniel Nevares. Announcement, counsel, please.
Good afternoon, Judge. Josh Avila for the state. State's ready.
Greg Anderson on behalf of Mr. Nevares, ready to proceed, Your Honor.
And Mr. Nevares is appearing from the jail annex. Mr. Nevares, I don't know if you could hear your attorney. Can you hear him okay?
Yes, ma'am.
Okay, he is having some issues, so you may not see him on your screen. His place mark there says Greg Desktop. We're having some video issues. Are you okay to proceed without having a visual on your attorney?
Yes, ma'am.
Okay, so we are scheduled for pleas in these cases. I think we're only having pleas on cause numbers ending 2003 and 0831. So we'll just go forward on those cases. Mr. Nevares, I'm going to be asking you questions, so I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you. You can put your hand down. Just please speak clearly enough so the court reporter can hear everything. Also, if at any point you're unable to hear us clearly, please just let me know so we can go back and repeat anything, okay, that you missed.
Yes, ma'am.
Okay. Sir, would you state your name for the record, please?
Daniel Nevares, ma'am.
Mr. Nevares, I'm going to be asking you about documents you may have reviewed with your attorney, the first of which is marked as State's Exhibit Number 1, one for each case. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Nevares, do you recall reviewing State's Exhibit Number 1 with your attorney and signing those documents?
Yes, ma'am.
And did you understand everything contained within those documents?
Yes, ma'am.
Mr. Anderson, have you had more than 10 days to prepare defenses in these cases?
I have, Your Honor.
And did you explain the plea papers to your client?
I explained them to him in person, Your Honor.
Okay, do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering pleas today?
I do believe so.
Mr. Nevares, are you satisfied with your attorney's representation of you?
Yes, ma'am.
And Mr. Anderson, do you have any reason to believe your client is not presently competent to enter pleas?
None, Your Honor.
Mr. Nevares, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir,
Yes,
are
ma'am.
you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso.
In El Paso, Texas?
Yes, ma'am.
Okay. So in cause number ending 2003, I understand the plea is only as to count one, that is for failure to comply with off-duty sex offender duty to register with a previous conviction. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty, ma'am.
And in cause number ending 0831, I believe it's the same charge as to count one only. To that charge, what is your plea, sir? Guilty or not guilty?
Guilty, ma'am.
Are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Avila, would you summarize the evidence?
Yes, Your Honor. Had the state proceeded to trial on count one of both of the cases you mentioned, Your Honor, state would have proven beyond reasonable doubt through competent witness and evidence, starting with the case ending in 0831 on count one, that on or about the 7th day of October of 2020 in El Paso County, Texas, Daniel Nevares did then and there, while knowing he was required to register with a local law enforcement authority in the municipality where the defendant resided or intended to reside for more than 7 days, namely El Paso County, because of a reportable conviction for aggravated sexual assault of a child, the defendant failed to report a person to the local law enforcement authority and provide the authority and officer with the person's anticipated move date and new address no later than the 7th day before the intended charge. And the state would have further proven that prior to the commission of the previously mentioned offense, on the 9th day of January 2013 in the 120th District Court, the defendant was convicted of an offense of sex offender's duty to register life or annually. And secondly, Your Honor, on case ending in 2003, had the state proceeded to trial on count one, state would have proven beyond reasonable doubt that on or about the 1st day of April 2021 in El Paso County, Texas, Daniel Nevares did then and there, while knowing he was required to register with the local law enforcement authority in the municipality where the defendant resided or intended to reside for more than 7 days, namely El Paso County, because of a reportable conviction for aggravated sexual assault of a child, the defendant failed to report in person to the local law enforcement authority and provide the authority or officer with the person's anticipated move date or new address no later than the 7th day before the intended change. And the state would have further proven that prior to the commission of the previously mentioned offense, on the 9th day of January 2013, in the 120th District Court, the defendant was convicted of an offense of sex offender's duty to register life or annually. And at this point, Your Honor, state moves to admit state exhibit number 1 as a plea agreement, state exhibit number 2 as our 39.14 obligation, and the summary of the evidence for the record.
Any objection?
Objection, Your Honor.
Without objection, states exhibits 1, 2, and the summary are admitted in each case. What is the plea agreement?
The plea agreement, Your Honor, is for Mr. Nevares to plea on counts 1 on cases ending in 2003 and 0831 and be sentenced to 6 years in the Texas Department of Criminal Justice Institutional Division, that no fine be assessed, both cases to run concurrent, and the state will be dismissing count 2 on each of these cases mentioned, as well as 2 separate felonies in your court, Your Honor, cases ending in 2017 and 2206, a burglar habitation and unlawful possession of a firearm by a felon.
Mr. Anderson, is that your understanding of the plea agreement?
That is correct, Your Honor. There may also be a failure to ID floating out there, misdemeanor, which I think is the intent is that it be either declined or dismissed upon filing. I think it's still P-file at this point.
I will look into that, Mr. Anderson, and I do not disagree with dismissing it. Just a question of either getting it filed or declining it.
Okay. So, Mr. Nevares, is that your understanding of the plea agreement as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about, again, one for each case, is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Nevares, do you recall reviewing that document and signing it?
Yes, ma'am.
Okay. They were signed by your attorney and signed by me as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. As to count one, in both cases, I will find you guilty of the offense of failure to comply with sex offender duty to register with a previous conviction. I will sentence you in each case according to the plea agreement at 6 years confinement in the Texas Department of Criminal Justice Institutional Division. Your sentences in these cases will run concurrent with one another and you will receive credit for any and all time that you have served. Once I have received the dismissal on the remaining counts and in cause numbers ending 2017 and 2206, I will sign those. It will be on the DA's office to follow that misdemeanor case because they are not handled in this court. Okay, is there anything further, Mr. Avila or Mr. Anderson?
Nothing from the state, Your Honor.
Nothing further, Your Honor.
Mr. Nevadas, were you able to hear everything okay?
Yes, ma'am.
Okay, thank you very much and good luck to you, sir.
Thank you, ma'am.
Okay, Annex, if we could get Benjamin Duarte, please. Benjamin Duarte. Mr. Duarte?
Yes, sir.
Okay, Judge.
Go ahead.
It's cause number 2018-0D04081, State of Texas versus Benjamin S. Duarte. Announcement of council, please.
Josh Avila for the state, Your Honor. State's ready.
Veronica Teresa Lerma, Your Honor, on behalf of Mr. Duarte, we are ready.
And Mr. Duarte is appearing from the jail annex. We are scheduled for, well, I think we're scheduled for a revocation hearing, but we were actually working through, I guess, the last discussion was last week, right, Ms. Lerma, where we looking at some treatment. Have you had a chance to speak with your client?
Yes, Judge. And if treatment and RSAT is something that's available for him and something that the court would consider, he would ask the court if his terms and conditions of probation could be modified to that.
Okay. Ms. Pineda, do you know, I thought was it SafeP? Were we talking about SafeP last time or what were we talking about last time?
We were, Judge. The reason being is because he had already been placed and modified to BHRTC. Right when he completed the actual BHRTC program, he had to attend and comply with the outpatient
right
bit of it, and that's when he there was relapse. He stopped reporting.
Okay.
Therefore, we were looking for something more structured.
Right. I recall that being SafeP. So if he's in agreement with that, I'm good to go with that. We can just get the modifications. Is that where we are, Ms. Lerma?
Well, Judge, I'll ask Mr. Duarte. I spoke with him about SafeP, and he said that his memory was that the probation office was offering him to continue on probation. But if SafeP is something that he would like, he could let the court know now.
So I don't recall anything other than SafeP. That's the only thing we discussed. The alternative was, I can't remember, 3 TDC. What was it, Avila?
With 2 TDC, Judge.
TDC. All right.
Mr. Duarte, would you like some more time to think about it, or would you like for me to call you, Mr. Duarte, about the SafeP?
AP, I don't know. I think RSAT would be good. I don't know why I wouldn't be able to go back.
Look, stop, Mr. Duarte. You're either getting SafeP or you're doing 2 TDC. Honestly, I was not at any more treatment with you. I am at my limit. So you either take SafeP or you get 2 TDC. I don't have a problem if you need more time, Ms. Lerma, to discuss that with him. We can come back on December 14th. But honestly, we just keep coming back and coming back.
Yes, Judge, I would ask if we could come back on the 14th, and I'll speak with Mr. Duarte on that.
I'll be happy to sign for SAP.
See you on the 14th, Ms. Lerma, 3 p.m.
Thank you.
Thank you. Who's next, Tree? Or you get 2 TDC. I don't have a problem if you need more.
I'm sorry,
time,
but
Ms. Lerma.
I'm getting the repeat feedback.
You can come back on December 14th. So mute it. I'm not sure why. So. All right. Get Mr. Owens if he's there. Annex, if we could have Mr. Owens.
You know what? I needed to close. Okay, Judge, I'm good now. Owens.
Go ahead.
Cause number 2021-020-2884. Cause number 2019-020-4549. Cause number 2019-020-4550. State of Texas versus Dominique Tremaine Owens. Announcement of council, please.
Josh Avila for the state, Your Honor. Stage ready.
Good afternoon, Brent Stevens for Mr. Owens. We're ready, Your Honor.
Okay, so we're scheduled on the two probation cases for pre-revos and bond hearings. We have that new 2021 case set for arraignment. I feel like we had discussed this one. The new case was a vehicle, and you can proceed on your bond hearing, Mr. Stevens.
Okay, thank you, Judge. I'm getting feedback also, so if you can't understand me, please let me know.
Sure.
Mr. Owens is 22 years old. He's been in El Paso about 4.5 years. He came here for the military, but he was released from the Army in October, or got out of the Army. He's originally from Texas. He has an address to live at with his wife if released here in El Paso, and his wife's family is from El Paso. He's currently unemployed. That's one of the points that he received on the pretrial services report, by the way, as being unemployed, but he barely got out of the Army in October. His wife is pregnant. He had hoped to eventually go to the oil fields to work, but has not, obviously has not done that yet. He's on 4 years deferred adjudication for 2 robbery cases in this court. They were from July 31st, 2000. But based on the allegations in the motion to adjudicate, it sounds like he was reporting, but the new allegations are there's a car theft charge, and there's also a Class B misdemeanor theft, a shoplifting, and I believe that was Walmart. It hasn't been filed yet, so I don't have the police reports, but I believe that was a Walmart case. So Mr. Owens has VA benefits, and if released, like I said, he does have a place to live. And on the pretrial report, and the other point he was getting was for pending charges. And then, of course, he's on probation. So those are most of his points that I can see. So we're hoping that the court will consider a PR bond on all 3 of the felony cases and allow him to report to court. He's not set for trial until June. The car theft case is very strange. I'm still working on it. I have received some documentation from his wife, and I've told her I can't really talk to her too much because I believe she has an attorney also, so I don't talk to her about the case, but she did send me documentation about a car sale. So I'm looking into that. It appears to have the same VIN number as the vehicle that's listed in the report. So it's kind of a strange case that I'll need to be speaking to the DA about.
Is that everything, Mr. Stevens?
Yes, Your Honor.
Okay, Mr. Avila?
Yes, Judge. I will defer as well to probation, see if they have anything to say about how he did on probation, Judge. But it seems like what happened was that first arrest, which was on October the 8th, for an incident that happened on October the 6th. I agree with Mr. Stevens that the facts are somewhat unique in the sense that it seems like the vehicle that he attempted to steal, or that he stole, excuse me, that he's alleged to have stolen, was a vehicle that he previously owned. He traded in that vehicle, and later on he ended up going to get a test drive and then took the vehicle. The only issue that I have, Judge, is that on that case, on October the 10th, he posted a $20,000 cash surety bond. He gets released that same day without a PR bond, and then what was it, 2.5 weeks later, he picks up a shoplifting case in Walmart. Right, this was a theft of a TV. I believe his wife or girlfriend is a co-defendant in that case, which might explain why she has a defense attorney. Your Honor, I don't see him ever doing theft counseling or community service hours in his cases. So while he may have been reporting, I don't necessarily see any indication that he might change or he might not reoffend, right? I will oppose any PR bond primarily because he picked up 2 new theft cases while he was out on probation for a robbery case involving a theft of some cell phones using an app. And I remember because I pled this case. He did post a $20,000 bond, Judge, so it seems like he might have the funds to post something similar to that, right? So that's all I have to say, Your Honor, on that.
So what we have holding him then are the 2 probation cases. Is he being held also on the theft case?
The Class B theft case is a $300 cash or surety bond. And the new car theft case is a $20,000 cash or surety. And there are no bonds on his 2 deferred cases.
Okay, so as we are right now on the felony theft, is he being held on that one? I heard you say, Mr. Avila, he posted a 20,000, but is he booked right now on that theft?
Judge, you know, I saw that he got released from that bond, but now it's showing that it's still holding him. I don't know why he got released. Maybe there was an agreement on the bond, or he had posted some surety and it got revoked because he didn't report. But right now it shows as $20,000 still, and it doesn't show it as it being posted.
You know what, Judge? I think, I'm not sure about this, but I think this may be a case where he bonded out, and then whenever the bench warrants were issued, that there was a surrendering of the bond based on a reincarceration, but
Right.
I'll have to double check on that.
Okay, that makes sense. Okay, so this is kind of where I see this one. I think ultimately, and this is kind of jumping ahead, I do have the case summary from probation. They're requesting a 60-day jail commitment. I think that kind of gets us over a bond in this sense. With
Correct.
respect to the 2021 case, I think a $20,000 bond, I'm not sure if that one has been pulled or not. I think a $20,000 bond is appropriate. So the bond on the arraignment on the 2021 case will be $20,000. With respect to the 2 probation cases, however, so that's 4550, 4549, where he has no bond. I think I would rather resolve that with the ultimate jail commitment on the violations that we have right now. So I think probation is asking for a 60-day jail commitment. I am good with a 30-day jail commitment on both, and he gets credit for the time he's in. So he's done, Mr. Stevens.
And that will close out the motion, right, Your Honor? I will
That will
dismiss the
close out
motion.
So we
Okay.
dismiss those 2. I think what I'm hearing is basically we have reoffended.
Right.
We have what I'm going to do going forward, Mr. Stevens, is still attach in terms of like a probation review. I will attach the probation cases to the new case, to the new theft. And your client must appear via Zoom at every one of those hearings, okay? In the interim, I'm telling you right now, Mr. Owens, you are getting a huge break because you've gone out and allegedly committed 2 new offenses while you're on probation. So 3rd one, and I'm not gonna wanna hear another bond hearing. He will just stay in, Mr. Stevens, until we get to our trial. So I think I'm good with that for now. All other terms and conditions are to remain the same, with the exception that he may not, we're gonna add some of these conditions into his probation that are on these new cases. So I don't know if we've already done something with respect to whoever the complainant is on the felony theft, no contact. I'm not sure, that sounds to me like a questionable situation there. But he also may not go into the Walmart that I guess is the subject of the other case, the misdemeanor theft. Okay.
Okay, thank you, Judge.
All righty, we'll get all that paperwork taken care of. Ms. Shafino, were you going to ask me something?
Yes, Judge. So you just wanted me to release him to continue on probation?
Correct.
Okay. Thank you.
And I will dismiss the motion once we get the mods in. Please include me on those emails so I can submit the dismissal.
Sounds good. All right, you are getting somewhat of a fresh start, Mr. Owens.
Judge, I'm sorry, I have a question.
Yes, ma'am.
As far as the 60-day jail commitment that was recommended, is he gonna complete the 60 days, or we're just gonna give him credit for what he's done right now?
So what I said is a 30-day jail commitment.
Oh, I apologize.
He is going to have, the time that he is in is going to satisfy that jail commitment. I think he has, at least his time of the docket, 34 days.
Okay, Judge.
He's done. All righty. Thank you, Mr. Stevens. Thank you, Mr. Owens. Who's next?
Thank you, Judge.
Okay, Judge, we can go with Taylor. Annex, if we can get Frederick Taylor, please.
Yes, sir.
Hi, Ms. Lerma.
Hi, Judge. I logged off and then I
didn't
realized, oh,
see
no.
you. I didn't see your second client is on the very last page. I'm sorry. I should have said something. I didn't realize.
I just remembered. I was like, oh my goodness.
You're like, I'm out of here. Okay, is this Mr. Taylor? Let's go, Tree.
Yes, Judge. It's cause number 2021-0D02596, State of Texas versus Frederick Elvis Taylor. Announcement of council, please.
Judge Avila for the state, Your Honor. State's ready.
Veronica Teresa Lerma, Your Honor, on behalf of Mr. Taylor, we're ready.
And Mr. Taylor is appearing from the jail annex. We are scheduled for a bond hearing. Ms. Lerma, before you get started, what is his bond right now?
Judge, I think, of course, I don't have that right in front of me. I want to say it's 100,000.
I thought it was 100. I thought it was 100, maybe split 99 in one, I think is the last I saw. So if somebody can look that up, that's okay. You can go ahead, get started with the bond hearing.
Yes, Judge, you're correct.
Thank you.
Mhm.
That's nice to hear. Okay, go ahead, Ms. Lerma.
Judge, Mr. Taylor is asking the court to consider reducing his bond at the amount that it is currently set. He is unable to make the bond. I'm appointed to represent him in this case. He is indigent and he doesn't have any money nor does his family to make the bond. If he was released on bond, Your Honor, he would reside at 4554 Hercules Avenue with his mother and father, Tamika Taylor and Frederick Alvis. He has a potential job opportunity at Food King where he would work as a stalker. I believe that his father has a job there and would be able to, or has verified that he would be able to get him a job there. He also is currently engaged. He has a 5-month-old baby whom he needs to start supporting and obviously cannot support in jail. He is a US citizen, Your Honor. He does have ties to El Paso by virtue of his mother and father and his fiance, as well as his child. And with respect to the current charge, Your Honor, there are certain conditions that the court can place to protect the community. And Mr. Taylor and I have spoken. He would attend his court hearings as required by the court.
Okay. Mr. Avila?
Yes, Judge. Just in full candor with the court, I would have no issue with reducing the bond from 99,000. My issue would be given a full PR bond, Judge. I would think, looking at the court file, because I was looking at the court file, I didn't think there was any bond hearings at JMAG. I didn't see any, but I would think the bond was set at that amount, or excuse me, I know now that it was reduced from 150 to 99,000, 99,000 cash surety with a $1,000 PR bond component. And my understanding from that is that it had to do with the nature of the offense, right, Your Honor? It had to do with the fact that this case involves a handgun being used in a threatened manner, as well as someone being pistol whipped with it, right? I would concede that he doesn't have any criminal history, Your Honor, but given the nature of the allegations, I do not feel that a PR bond would be enough. I would think somewhere between 20 to 30,000, perhaps. And we are in contact with the complaining witness, Your Honor.
Okay. Are there co-defendants, or did he do with the allegations just him, or what is it?
I opened up my notes, Judge, because you caught me off guard. It is just him, Your Honor. There was a passenger in the vehicle that he was with, but that person had nothing to do with the case. And I believe Mr. Taylor and the passenger were previously dating or used to date or something like
that. Anything else, Ms. Lerma?
Just that the court consider reducing his bond, Your Honor. This case may take a while to get to trial or to be negotiated, and we're asking the court to consider releasing him.
Is there a rec right now, Mr. Avila?
Yes, Your Honor. I have a note. I uploaded a for TDC rec with the possibility of probation, given my contact with the complaining witness, his mom, and also my plea negotiations with Ms. Lerma, any mitigation.
Okay. All right. For now, what I will do is, Ms. Lerma, again, if he doesn't have any resources, it may not help you, but because he does not have an extensive criminal history, I don't see anything here. So you've looked at the rap, Josh, and there's nothing there?
I looked at the rap, Judge, and I tried to look to see if it's the same one, and yes, I didn't find anything.
Okay, so I'm going to reduce the surety cash portion from 99 to 40,000. The PR component will remain the same, so I think he's on intensive. Again, I don't know that really helps you, Ms. Lerma, but that's kind of considering the nature of the offense and the allegations. I'm going to stick with that for now. Okay, if you need to approach the court again on a bond hearing, let us know.
Yes, Judge. Thank you very much.
Thank you. Who's next, Trey?
Hey, Judge Rios on page 9. Annex, if we can get Refugio Rios, please.
Yes, sir.
Your Honor, before we go into the bond hearing, may I address something really quick on this case?
Sure.
I don't know if you want to announce, counsel.
Do you want it? Well, do you want to, yeah, or is this just, you want to talk, or you want to be on the record?
I just want to clarify on the dismissal, Judge, and I kind of ask a question about a recent rec that was given.
Oh, okay, let's just get on the record. Go ahead, Trey.
Yes, Judge. It's cause number 2016-0D0-4953. Cause number 2021-0D0-1590. State of Texas versus Refugio Rios Jr. Announcement of counsel, please.
Josh Avila for the state, Your Honor. State ready?
And good afternoon, Judge. Denise Butterworth on behalf of Mr. Rios, and we are ready as well.
Okay, so Mr. Avila, we're scheduled for a probation status hearing, a bond hearing. We had one dismissal on 1590, but you wanted to discuss something first?
Yes, Your Honor. Like you indicated, Your Judge, I submitted a dismissal on the possession case, given that we hadn't had any lapse back, and the offense has been over a year now from the date of arrest. The second thing, Your Honor, that I wanted to approach is I know Ms. Butterworth had received an offer recently regarding him pleading on some lesser included on the new case with keeping him on probation on the probation case. I don't know, Ms. Butterworth, did you get that email?
I did. So Judge, I'm going to look for your guidance on how you want to proceed this afternoon. I received an updated rec yesterday, so I have not had an opportunity to talk to my client yet who's out at the annex. So I was going to, number one, ask if I could get a breakout room at some point to see if I could go over with him the new recommendation. And then I'm not sure, because I can't see on my screen if Mr. Flores is on this call.
Yes.
This is who I'm negotiating with, and it's a very reasonable rec right now. I'm trying to finalize it. So I've been chatting with him back and forth so that I can have an answer for.
That's the I just got a chat look. Okay. Yeah.
I guess what I'd like to do.
So let's take a quick break.